Right from the start, this hearing takes an unusual turn. Instead of simply identifying himself, the defendant begins making arguments the judge has likely heard before. But regardless of the terminology used, the court's first job is simple: confirm who's in front of the bench and determine whether the hearing can legally move forward.
All right, 23 DCCR 0319 on Lupe Gomez. I've got Mr. Nichols here for the state. Mr. Radford is here. Sir, you, Lupe Gomez.
I'm sorry?
Is your name Lupe Gomez?
I've been on for
What?
third-party intervener, cross plaintiff, superior lien holder, to appear by special restricted visitation and not by general appearance.
Can you do this? Can you come around and have them so I can see better?
You want us off the bench, John?
Yeah, y'all can all come up here. Okay.
So I have a couple questions.
No, well, hold on. You don't get to ask questions. I'm going to ask the questions. Mr. Gomez.
Can happen until all parties are identified into the record.
All right. So, Mr. Tell me again who you are. Who are you saying
I'm
you
a
are?
non-corporate third-party intervener, here by special restricted visitation and not by general appearance, under duress by the means of threat, coercion, and kidnapping.
Okay. Have you ever been known by the name of, in the past, Lupe Gomez?
Will you state your name for the record, please? And will you order the prosecutor to state his name for the record? And do either one of you have a claim against me?
We do have a claim against you. My name is Raquel West. I'm the judge of the 252nd District Court. This is Mr. Luke Nichols. He's one of the assistant district attorneys in my court. Mr. Radford is here representing you.
Okay.
There's an indictment. There's a motion to quash. Mr. Radford has filed that we're here for today. I'm going to take judicial notice of the court's file, which includes numerous documents, including a indictment, the probable cause affidavit, other identifying information that does identify you as Mr. Lupe Gomez. And I'm going to make the finding at this time that you are, for purposes of this hearing, Lupe Florencio Gomez. And we're going to go forward with the motion to quash. Mr.
That's a motion to suppress it.
Motion to suppress. I'm sorry. Let me get that pulled up. I have a motion to quash as well, correct?
Yeah, you do.
Hold on.
I think that's a pro se motion.
Okay, so we're here on Mr. Radford's motion to suppress. Let me find that one. It's okay. I'm looking.
Well, while you're doing that,
Nope, stop talking.
Onto the record,
Stop talking.
Your foreign agent's registration statement.
My what?
Are you refusing to do so?
I am.
Okay.
Here we go. All right, so Mr. Radford filed, it's entitled Motion to Quash and or Suppress Evidence.
Oh, okay.
And that's why I was confused, because it just showed the first part. And 23 DCCR 0319, this was filed April 29th of 2024. And Mr. Nichols, you may call your first witness with regard to the suppression.
State calls Officer Chad Morrison.
Would you please call the name?
Officer Chad Morrison. No response, Your Honor.
All right, Mr. Nichols.
Your Honor, I have no other witnesses, and this time for this hearing, the state rests. May I make a statement on the record?
Yes, you may.
Your Honor, I was in contact with Officer Morrison.
This is a major turning point. The prosecution's witness, the police officer central to the suppression hearing, never appears. In criminal court, prosecutors carry the burden of presenting evidence. When they can't do that, judges don't have much room to maneuver. Procedure matters just as much as the facts.
Last week, he is formerly of Port Arthur Police Department. He now is with a different agency in the greater Houston area. He indicated he is on injury leave at the moment and would not be appearing for this hearing. He was also on injury leave and was unable to appear last time we were set for this hearing, approximately 2 months ago, maybe in May. So at this point, the state has no other option but to rest in this hearing and present no other evidence.
Just like that, the case is effectively over. Once the judge suppresses the evidence and the prosecution has nothing left to present, dismissal becomes the logical next step. It's a reminder that every court hearing can hinge on something as simple and as significant as whether a key witness shows up.
All right. Anything, Mr. Radford?
No, ma'am.
Well, based on that, then unfortunately, I have no choice at this point, which is unfortunate that the officer won't comply with showing up, but I'm going to grant the motion to suppress evidence in the case based on the fact that there's no evidence today presented. Is there anything else, Mr. Radford?
I would ask that the court dismiss the case, but I think Mr. Nichols is already preparing that.
I'll tender dismissal of the court, Your Honor.
All right, Mr. Gomez, I have granted Mr. Radford's motion to suppress because the officer didn't show up. What that means is there's obviously no evidence that would be able to be presented in your case. Mr. Nichols, it looks like, is going to present a dismissal based on the fact that there won't be any evidence, and I'm going to sign that. Your case will be dismissed.
Okay.
You can go back with the bailiff.
The bond money, being that the case has been dismissed, the bond money needs to be returned.
Did you pay a cash
I paid
bond?
cash, $5,000.
But you're back in custody.
You're right. I still pay. The case is this.
Yeah, that you can take that up with the district clerk once you're released. All right.
May I be excused, Doctor?
Yes, if you'll please get me an order. I'm going to make a notation on this, but if you'll send an order.
I'll try to e-file one this afternoon.
All right, thank you. Mr. Escalates, when did you smoke pot? Why would you do that when you know you're coming to court for a second-degree felony offense? It's common sense that you're on bond for a felony and you're coming to felony court. No one should have to tell you to follow the law, right? I'm going to raise your bond it is a bond condition that you follow the law. So when you made bond, part of your conditions was that you follow the law. You haven't followed the law. I'm going to raise your bond in your case. What was the bond that you made? Let's see if I can figure that out. How old are you?
27.
Yeah.
I never made any mistakes since I quit this. I paid all the time, came to court on time.
Are you working?
I'm just lost my job recently for transportation. What I'm saying, I have a newborn, man. My daughter's 3 months. I'm trying my best.
You're trying how are you hold on. What are you doing to help your child that's 3 months old by smoking marijuana? Because if you go try to get a job and you test positive, you can't get a job. How's that going to help your daughter? So you are making mistakes. You're making ridiculous choices. You can go to prison in your case. Don't talk over me. You can go to prison for up to 20 years in this case. And to take a chance while you're out on bond, when you should be trying to get a job, and instead you're out smoking pot, you're not taking care of your daughter. Am I correct?
Judge, if I may, after the court would consider amending his bond condition for the drug patch in the situation in lieu of raising his bond and putting him back in custody.
Sure.
I'm 27. I've never had any drug charges, anything like that at all. I'm gonna be honest. I know I shouldn't have been smoking, but in my head, I'm saying, okay, I'm not going for a drug charge. I don't have